Northern Ireland, a small step to a giant adventure. Book your next giant adventure at discovernorthernireland.com.
Fáilte Ruamh go Féile an Phobal ó Áras Ó Connollia. Welcome to Féile an Phobal. I am at the James Connolly Visiting Centre in Belfast. My guest, Fionnuala Ó Shaoláin, is joining us from the United States, and she is the current UN Special Rapporteur on the protection and promotion of human rights and fundamental freedoms. She is also University Regent Professor at the University of Minnesota and Law Professor at Queen's University. She has also widely published numerous academic articles and books, and the recipient of many academic awards, including the Fulbright Scholarship. I came across your book, The Politics of Force, in 2000, Fionnuala, when I was a law student, and it's still a useful reference book for me in the work that I'm doing. But I want to go right back to how you came to Belfast. I know you're a proud Galway woman, but you studied at Queen's University, so maybe you tell us how you ended up in Belfast and how that might have impacted on your later career in international human rights law.
Gur míle maithid, anna hasarma bheithin seo tá sé sanor mhór samsa bheith in an leabharrta go bhéile tar éis blianta fada a géisteacht leis bhéile agus a caint faoi sa tá anna hasarma bheith inneo mór trú nach chun muid le chéile. So I'm really glad to be here and very glad to join you after many years of being a visitor to Féile. To be a guest at Féile is a real honour. So yes, I did. I came to Belfast in 1987, which feels like an absolute lifetime ago, to study law at Queen's. And I had in my youth, when I decided I wanted to be a lawyer, I grew up in Galway, but I had a really profound interest in human rights, really nurtured probably by my family and my father in particular. And at that time, Queen's was, and still is, of course, one of the preeminent universities in the field of human rights. And even as a young 18-year-old in Galway, I knew that some of the best people doing human rights in the world were at Queen's. But more than that, I had a sense, my mother's from the north, and I had a sense that the conflict was sort of entwined in our family life as a result of that. And I had a sense that if I was going to study Queen's on the island of Ireland, the only place to study human rights would be at Queen's. So I came in 1987, and of course, studying law at Queen's in that time, as you know yourself, had an enormous influence. I joined the Committee on the Administration of Justice, CHA, in my first 2 weeks at Queen's in 1987. I think at that point it was an organization with one room and a kettle somewhere on Donegal Street. And so my whole life as a student was really framed by both pursuing the study of international law and human rights, but also as an activist. I think I was an activist human rights lawyer in the making from my very first arrival in South Belfast in 1987.
Well, your career in human rights has taken you now all over the world. It might have started in Belfast, but certainly you've had a very impressive career and a journey over the last couple of decades. And I want to take you back to the earlier part of that, maybe to your role as representative of the prosecutor of the International Criminal Tribunal for the former Yugoslavia. I travelled often to former Yugoslavia, and in the last number of years, I have a great interest in that area of the world. And I have gone to the museums in Sarajevo, and the barbarity of that conflict, I'm well aware. But it must have been very difficult for you to deal with that and you know, to see and work through those cases in the former Yugoslavia. That must have been quite an experience for you.
It was, but I suppose I always feel like the golden thread that has worked through my life as a lawyer and as an advocate has been the foundational experiences that I had living in Belfast, working particularly. My PhD was on the use of force. It addressed the use of force against civilians over the course of the conflict. As a result of that, I spent a fair amount of time as a very young learning lawyer with families, with lawyers, with the coroner's office. I had access to all the inquest files that were then available in the early 1990s to write that first book, The Politics of Force. So in a way, all of that, I think, gave me the foundation stones to go out. When I went to the former Yugoslavia, I went as a representative of the prosecutor. And at that time, one of the big challenges was, in fact, getting cases to The Hague. There had been an agreement to establish an international criminal court, but actually they were caseless. There were very few cases. And Sarajevo, I lived there for the last year of the war, in a city that had that was a bombed out remnant of itself. Sarajevo is one of the great cities of the world. It was a place of tolerance, of coexistence between Christians, Muslims, and Jews for centuries. And to see that city destroyed through the war, but also I think, one of the things I learned there is just how difficult it is to do justice. I mean, that's the reality. Even when you establish an international criminal court and you send experts like myself or others to do the work of trying to bring perpetrators of war crimes, genocide, crimes against humanity to account, even with all of those systems, actually it remains extraordinarily difficult to prevent impunity. But what also stands with me, and I've also had the opportunity to go back since that period when we were, wearing flak jackets, and our first day was learning, as representatives of the prosecutor, your first day of training is learning how to identify landmines so you don't accidentally step on one as you're going to do your work, is the extraordinary resilience of people, the warmth of the people of Sarajevo, and actually the enduring commitment to accountability. So I had the extraordinary privilege to meet some of the survivors of Srebrenica, and to understand their quest to have those they loved accounted for. And that quest is still with us. So yeah, I learned a lot, but all of these are they build on the foundations of what you have.
Okay, and I wanted just to take you on. You were then appointed by the Irish Minister for Justice to the Human Rights Commission sometime around 2000, and you held that post for 4 or 5 years.
Yeah.
And then you were nominated by the Irish government to the European Court of Human Rights. You were the first female academic lawyer to do so. So, I mean, that period in your life, you moved on from the work in Yugoslavia. Can you tell us a wee bit about that period and what that involved?
Yeah, so, that first period of I suppose you'd call it the post-Good Friday institutions, right? All these new institutions that were created north and south. And interestingly, as I think many of the listeners would know, the Republic of Ireland was not entirely enthusiastic about having a Human Rights Commission created. There's an interesting lesson from that, really, which is that in the north, we've actually had to accommodate new institutions for much longer and centralize human rights in our discourse. And we may be very, very critical of that, but just peep over the border and what you see is really that lack of institutionalization of human rights, partly because there's this complacency that because there's a constitution, you don't have to do human rights. The constitution takes care of it. And as we've known from the mother and baby scheme, from the continued existence of the Special Criminal Court long after the conflict has ended in the Republic, actually the embeddedness of human rights in the Republic of Ireland remains quite fragile as an institutional matter. So I served on the commission, and it was a very controversial commission in the first instance because the appointments process was open to some great concern really by sort of the crony appointments process. So we ended up with a very large commission by virtue of the fact that new members, more independent members like myself, were brought on to the initial set of appointments made by the minister. And I would say, what did I learn from that? Well, I made extraordinary friendships. People like Michael Farrell, who was exceptionally, I want to say, influential on my life as a young lawyer. Michael's great book, The Orange State, is one of the kind of cornerstones of my own reading and shaped my thinking as a young person. Nuala Kelly, who worked on issues of prisoners, Clodagh McRory. So there was an extraordinary group of people on that commission. And so in many ways, the learning I did on that commission was very much from the people who were appointed with me. I think regretfully, the commission in the South didn't really ever live up to its potential. Some of that was the stymieing of it from these bigger institutional forces. And the other piece of the commission's work, I think, that was really was under-enforced was the charter for the island of Ireland. There had been a sense that there would be this cross-border entity between the two human rights commissions, and that would provide a framework of rights, common rights discourse across the island. I think regrettably, that's one of the things that really never solidified. It's one of the unfinished pieces of work on the Good Friday Agreement.
Yeah, I think there's quite a few bits of unfinished work. This Good Friday Agreement, we're still grappling with some of those issues. One of those, of course, is that the Bill of Rights, which has been an issue here in the North the last number of years as well. You've also a keen interest in gender equality, and you were also appointed the Secretary General of the UN as a special expert on promoting gender equality in times of conflict and peacemaking. And you've also published widely in this area as well, so it's a particular interest for you. Can you tell us how important that issue is, particularly in those areas of conflict and post-conflict around the world?
Yeah, and I suppose I'd start by going back to Belfast in 1987 when I first started doing human rights. And I mean, I think one of the telling things is that in that period, you know, when many of us were kind of engaged in human rights work through different organizations, that gender wasn't a conversation, actually. Well, there was the women. I mean, I say this because many mainstream organizations didn't embrace gender. There was a women's sector. There was an extraordinary, vibrant set of women's centers, still one on the Falls Road, on the Shankill Road, lots of these extraordinary women and organizations, but they were out there. And then civil and political rights issues, for example, around the use of force, the use of torture, inhuman and degrading treatment, all of these discussions were kind of genderless. And I say that I've criticized my own work retrospectively by saying, if I were to rewrite the book I first wrote on the politics of force, I would now think about not just the person who'd been killed, but the gendered impact on the families, because we know, for example, that most often the profile of a person who was killed during the conflict was a young man or a man. But that didn't mean actually that the victims, that there wasn't an effect on women. In fact, in many cases, families, then you had single-headed female household with large numbers of children, managing not only the kind of scrutiny of the state as the result of the loss of a family member, but all of the gendered impacts, economic, social, and psychological of managing a family and navigating society in the aftermath of loss. So I would say that really I had it wasn't that I wasn't conscious of those issues, but it really was something that developed for me over time. And it really, my work in the former Yugoslavia, which focused particularly on gender and sex-based violence, systematic rape, systematic sexual harm, really awakened me to the centrality of a gender analysis in conflict. Of course, with a focus on violence, but also recognizing the other kind of multiple sorts of harms that women experience through conflict, many of which are invisible. In addition to that, what we see is the sidelining of women in the resolution of conflict. We certainly have had that problem in Northern Ireland. We have a vibrant set of women actors in different political parties, but that's a relatively new phenomena, frankly. And we still struggle with the kind of misogyny in public life that makes it okay to say things about women that you would never say about a man in public life. And I bring that work with me today. When I was appointed Special Rapporteur, I made a commitment to mainstreaming gender and gendered perspectives into the work I do on conflict and counterterrorism. And I have tried to do that consistently, sometimes with great resistance from other UN actors and states. But yes, the thread is really one that goes through, and it's I hope a consistent commitment in my work now that the gender piece is central to all of the thinking and the advocacy that I do.
You took up your role with the UN, I think in 2017. And I just want you to talk, because many of our audience will be familiar with your work over the years, but maybe in terms of your role as Special Rapporteur, how did that come about? And what does that mean in sort of day-to-day terms? What does your role involve? Yeah. And obviously a very important role, but take me through a normal day for you.
So my normal day starts about 6 in the morning. Because I'm based, I'm calling myself a COVID refugee these days, although I have a split appointment between Queen's and Belfast and the US. I've actually been mostly based in the US through the COVID pandemic. So I have an office in Geneva. The UN Special Rapporteurs have support staff based in Geneva, which is where the UN Human Rights Council sits. And my appointment is from the Human Rights Council. It's a political appointment. You're appointed by states, but as an independent expert. So I'm
appointed by the Irish state, presumably?
No, you're appointed by a vote of all states. So you have to actually get through the council, which means, you have to get states like China and Russia and the United States. And so it's a political process. And it helps if you have the support of your government. And I believe it's appropriate to say when I was appointed, I was supported by both the Irish and the British governments. And I actually would say, given that I had spent 20 years being a fairly vocal critic of human rights policy in Northern Ireland, I was actually pleased to see that both governments were prepared to support the work that I do and actually continue to remain supportive. So you're appointed, you have an office support in Geneva, but I still have a full-time job as a law professor. So one of the challenges for UN special rapporteurs is that we're independent experts, but we continue to work our full-time jobs. And the job I hold is not a part-time job. I deal with the negative impact of counterterrorism policies in every state in the world, meaning Turkey, Kingdom of Saudi Arabia, China, Russia, the United States, Latin America, name your country, we have work in that country. We have very few resources, so that means we often have to fundraise for our own resources. And I've been very lucky. I have 2 universities who support the work. So I have 4 full-time lawyers working for me. One of them covers the work in Geneva, but I also have a role. The mandate I hold has a role in what's called the New York security architecture. So as many listening will know, after 9/11, a really big explosion in global counterterrorism happened, and it mostly happened in New York. We have a Security Council, we have a counterterrorism committee, we have an executive directorate on counterterrorism, and we have something called the Global Counterterrorism Compact, made up of 43 UN entities. And I am considered one of those entities. So my average day starts at 6, and we work Geneva from about 6 to lunchtime, which is obviously with the time difference here. Then Geneva closes up around the middle of the day. And then we really turn to our New York work, where I sit on 8 counterterrorism committees in New York, but also have ongoing and sustained engagement with the Security Council and other counterterrorism entities and human rights entities. And then, of course, there's all the work with states, bilateral work with states. So my days are really long, really busy, and sometimes, things happen and you can't predict what your day may rarely ends at 6 o'clock, I guess, is the moral of the story.
Yeah. Well, I mean, I think you have stated that your mission was to make your role redundant at the UN. I suppose you want to see a much smaller, I'm quoting you here, much smaller counterterrorism footprint in the UN, and see the empowerment and support for other areas of UN policy which really address the conditions conducive to violence. So tell me a wee bit about that. I mean, we are in a world where the international human rights framework, that was established after the Second World War, is being dismantled, particularly after 9/11, and now we're coming up to the 20th anniversary of that. And it's time, many would say, that we reassess, or the world should reassess how it deals with these issues. So in your role, how do you encourage states who now are now very comfortable with a restrictive human rights regime, a more restrictive regime? How do you convince them? I'm sure it's a hard sell to some of these states, particularly some of the bigger states. How difficult is that for you, and in what ways do you try to do that? And how impactful is the UN's work then in terms of addressing all of that? And what are the alternatives? How do we deal with these conflicts in a different way? And obviously, you may go back to Belfast again, that we had a very military security response to a political problem, and that was quite disastrous in this jurisdiction. And I'm sure that applies to any part of the world as well.
Yeah. I know there's a lot in there. I think
3 questions, Fionnuala.
That was 10 questions. That's all right. Good. All of them good. I mean, I'd start by saying that I think many people would be, unaware of how extraordinary, enormous the global counterterrorism architecture is. That's what I call it in my work, the global counterterrorism architecture. And it's had an explosion of institutional presence, normative presence, policy presence post 9/11. And let me describe a couple of the ways that it's grown. So one is that we built this brand new, extraordinarily large architecture within the UN system. So not only, there used to be a Security Council, but many people don't know that after 9/11, through a Security Council resolution, we created a new committee right below the Security Council called the Counterterrorism Committee. And it's made up of the 15 members who also sit on the Security Council. So most people look at the Security Council and say, oh, that's a really dysfunctional body. God, they can never agree on anything. They don't do very much. They won't agree on Syria. They're, very ineffective. But if you just layer one layer down and you look at what happens in the counterterrorism space, what we see is an extraordinary consensus in state work just below. And that, in my view, has been disastrous for human rights across the globe for a number of reasons. The first reason is we have no globally agreed definition of terrorism. We do not have a multilateral treaty on terrorism. States have spent over 30 years trying to agree one in the 6th Committee of the United Nations to create a treaty. And the result is that what we have at the Security Council is the perfect gentleman's agreement. And it is a gentleman's agreement, not because I think if there were many women in that room making that decision, it wouldn't look quite the same. And the gentleman's agreement is that every state gets to define terrorism however they want without any negative result from that, meaning every state gets to define it on its own terms. So in the Kingdom of Saudi Arabia, which my mandate visited and I reported on in 2017, women drivers are considered terrorists and are charged under terrorist statutes because they engage in acts that the Kingdom of Saudi Arabia considers to be terrorism. In China, democratic protesters in Hong Kong, are the first of whom was convicted yesterday under counterterrorism law, are considered terrorists for engaging in what I consider to be legitimate and protected protest and speech under international law. In Turkey, for example, we see hundreds of lawyers detained under terrorism statutes for defending their clients who are accused of terrorism because they engaged in criticism or in pro-democracy or pro-change activities in their countries. So what we have around the globe is an epidemic of the misuse of counterterrorism practice, enabled and supported by this sort of legitimate space that was created post 9/11 in the Security Council that encouraged and supported and actually required states to do more counterterrorism regulation, but did not define what that is and left it up to states to do what they wanted. And if you're a state with a slightly authoritarian or, let's say, anti-democratic leaning, and you spot this permissive environment and this enabling and legitimizing environment at the global level, what it gives you is the imprimatur of allowance to go ahead and use counterterrorism language to do what you do. And so that's what we've seen. And so what my mandate has been tracking since it was established in 2005, two of my predecessors and now me, is tracking and calling out that global epidemic of misuse. So I think that's one really big piece of this, a huge new architecture, an emphasis on regulation. And just to close off, the point you made, or that I've made, I suppose, that about this for the UN, is that what this is doing is essentially displacing the historic work of the UN Charter, the focus on peace, the focus on conflict resolution, the focus on development, and the focus on rights. And I've described it as like a Pac-Man. I don't know if your audience is, where it literally eats. So counterterrorism eats everything up because it moves into, we securitize development, we securitize peacemaking. We use in places like the Sahel is a good example right now, where the response has been an extraordinarily militarized response to a highly complex and fragile environment where there are clearly non-state actors engaged, some of them in acts of terrorism. We're not disputing that there are serious acts of violence to be dealt with. But the securitization of that space and the really hard focus on military responses to complex problems at the national level doesn't solve anything.
Yeah, so how do we refocus? I suppose this is part of your role, the UN's work on those areas of peace, development, human rights development, as you've talked about it and you've been involved in. How do we refocus the UN? Or it doesn't seem like a very easy job for you or others in the United Nations.
I mean, I think it's extremely hard, bearing in mind that my office is the only office within the UN system which is given the responsibility of the oversight between counterterrorism and human rights globally. If states really wanted, when we say the UN should do something, what we really mean is states should do something, because the UN is no more than and no less than the will of the states who comprise it, right? And so one of the challenges here is that actually we see no willingness by states to reshift focus. One of the things I've been advocating most strenuously for is that, first of all, we need a full-time, sufficiently and adequately resourced, and sufficiently high-level appointment of a mechanism like a UN ombudsman to oversee the work of the UN itself on counterterrorism. And I came really close. We had a global, every 2 years, the UN negotiates a global counterterrorism strategy, and states this year, up until almost the 11th hour, were in process of creating that independent ombudsperson. But we lost that mechanism in the final negotiating hours. But I remain hopeful. That's one route, that we have an oversight mechanism, independent oversight of the UN's work on counterterrorism, because it undermines the UN Charter for the UN itself to be engaged in supporting states who are engaged in acts of repression, coercion, and using counterterrorism as cover for the most egregious human rights violations. It's simply unacceptable that the UN itself, its own reputation, should be marred by that kind of work. But the second thing we massively need to do is to prune global counterterrorism. As you said, we're 20 years on from 9/11. And I often ask, I say to states, and like I ask them, is any of this working? Any of it? Have you done any monitoring and evaluation of if your goal is to get less terrorism in the last 20 years, less violence in society, do you think these things that you're doing are working? If you don't have to ask a human rights question all the time. You can just ask a value for money question. You can ask an effectiveness question, and you can say to them, what are you actually getting for the money that you're spending on this? Wouldn't those resources be much better directed towards these other areas that really address the underlying conditions conducive, the absence of good governance, the absence of the rule of law, the failure to protect human rights, the lack of economic opportunities in places where, for many young men, it's a rational decision to join a non-state armed group because there's no economic alternative. And so I think those kinds of hard questions are the questions that I get to ask every day. But it's a really hard place because we're seeing constriction of democracy across the globe. We're seeing constriction of the multilateral space. And we're seeing the currency of human rights being degraded across the world. So this makes arguing against the current models of counterterrorism extremely hard.
Well, how do you think you can address the root causes of these conflicts in a way that, I suppose, respects human rights and can undo the counter-terrorism framework that's now in place that you've spoken about there? So in what ways can we do that address conflict? I suppose, our experiences here is that these issues are very, very difficult. They're very complicated, and I'm sure that's no different than many of the conflict zones that you're working in. So how can you do that in a way that respects human rights and doesn't undermine the rule of law?
I mean, I want to say it's really hard. And I think one of the things we've learned at home in the last, 20 years plus, peacemaking is really hard. The idea, I think maybe there was this idea, maybe it's best illustrated by that image on the White House lawn of Yasser Arafat and Rabin and President Clinton standing together, the kind of candid camera moment where it looks like the conflict is solved because three men are standing and looking like they've solved the conflict. And I think one of the things that happened post the Cold War, ending of the Cold War, was that we had an unreasonable optimism about the capacity of the, quote, deal making to solve the underlying issues. And that doesn't mean that the deal making or those moments, those evocative symbolic moments, aren't unimportant. They are important. They signal something about change. It's important, I think, to think about those moments in our own conflict, when even though we can be very cynical about those moments, they still represent something about the capacity for transformation, of shifting relationships between old adversaries and the challenge of moving the discourse in a different way. So I think that piece of peacemaking is important. But what have we learned? We've learned that actually addressing the conditions conducive to violence is really hard, because it involves shifting power. Power is really hard to shift. And one of the things we know is that power reasserts itself when it's been taken away. So I always think of the struggle for human rights as like the myth of Sisyphus, you know, the myth where Sisyphus is pushing the big rock up the mountain and it's heavy and you're doing this and you can't see the top of the mountain as you're pushing the rock. All you can see is the rock and you never know when you're exactly going to get to the top. And then you get to the top, and we've all had those moments of victories. I think perhaps, you know, Ballymurphy might be a really good example of a moment on the top of the mountain where you something has been won and the struggle has recognition. But then in many ways, what happens is we watch the rock go back down again. And we recognize that actually the mountain we've reached, there's another mountain to reach to get to something else.
That's what it feels like. You get to the top of the mountain, you take a deep breath and you go again.
You go again.
And that's often how it feels. And I want to come back to the British government proposals on legacy. I won't be leaving this without asking you about that. But before I do so, I suppose I want to talk about the situation in Syria, which remains dire. I know that many of us are watching the images from our homes, the distressing scenes. But you've been involved in work, especially in those camps. I think it's in northeast Syria. Yeah. And in February 2021, you were one of 23 UN experts urging the 57 states to repatriate women and children from these squalid camps. I'm just quoting from those experts. Thousands of people held in camps have been exposed to violence, exploitation, abuse and deprivation, and conditions and treatment that may well amount to torture or other cruel, inhuman and degrading treatment or punishment under international law with no effective remedy at their disposal. Can you tell us about the situation in those camps and maybe explain the reluctance of Western governments to bring home their nationals? And I'll talk about the Begum case in a wee minute, but perhaps tell us about those camps and what you have learned from that.
Yeah. So yeah, this issue of the situation in northeast Syria has been at the heart of my mandate's work for the last three and a half years. One of my legal advisors is working on it almost full time. So I think it's worth remembering, how did we end up with these camps? Well, at the end of the war, as the caliphate collapses, and I just want to be clear, you know, the focus here is not to underestimate how extraordinarily brutal and horrifying the ISIS caliphate was. Again, important issues that the mandate works on too, around accountability for crimes of genocide against the Yazidi people and others, crimes against humanity, war crimes. All of those accountabilities are still outstanding on that crime, on that war, that conflict. But at the end, as the caliphate is falling, large numbers, mostly of women and children, are being heralded into camp-like holdings in northeast Syria. The camps were created by the Syrian Democratic Forces, one of the non-state actors in the conflict. And currently we have at least 60,000 women and children being held in those camps, the vast majority of whom are what we call third country nationals. They're from countries outside of Syria and Iraq. And they include Irish people, one Irish woman, Lisa Smith, and her daughter, Britons, French, Russians, 57 countries have nationals in those camps. And my mandate led that letter writing to those, what we call a communication, which is a formal communication from the UN to those governments, for the first time naming all of the states. So everybody knows now who has nationals in the camp. We did that exercise of identifying and making clear that they had a responsibility to return. Now, the situations in the camps are horrific. They open latrines, flimsy tents, extraordinary dangers of violence. And for the children in those camps, no access to the most basic of healthcare. And that was pre-COVID. So can you imagine what this looks like in a COVID landscape? But what we've seen is the persistent resistance of Western governments in particular to bring back their nationals. I've worked with countries like Kazakhstan. I work with the Russian Federation. We've seen some countries bring back very, very large numbers of their nationals. So I was in Kazakhstan a year and a half ago at one of those moments where they were bringing back over 600, almost 600 women and children. And we were there to assess and review what the government was doing. So I've seen firsthand both the extraction and the repatriation of individuals and how it can be done in a human rights compliant way. But what we see is these countries who say they care about human rights, these countries who say that they have foreign policies that are human rights compliant, these countries who talk about things like children in armed conflict, who make great speeches at the UN, but who simply refuse to return their nationals, point blank, and engage in a practice of citizen dumping on other countries who have no capacity. Not only, if these individuals have committed crimes, my view is try them. If they've committed serious crimes under international law, bring them back, charge them with those crimes, and hold them accountable in fair trials. But if they haven't, you still have to bring them back and ensure their reintegration into society. And what we see is almost no movement and no willingness. And of course, it's a double standard. The states turn around and say to me, rightly so, they say, these countries who say that human rights really matters, these are the countries who won't take back their nationals. So why should we do other things that they say are human rights compliant? And so I absolutely have said and continue to say publicly that it's a double standard and that these states are obliged by international law to bring back their nationals. We should not be fighting these cases. For example, I know we'll talk about Begum, case by case in the courts of these countries. By the time we get through the litigation, these children, many of whom are now under the ages of 6, will be young adults. And your window to give them meaningful, dignified lives without the kind of harms that they're exposed to every day is just gone. It's gone.
Yeah, and you've intervened. You just mentioned the Begum case and the British Supreme Court case. Could you maybe tell our audience just a wee bit about that for those who haven't heard about it and the significance of that intervention? Yeah,
so some in the audience may have heard about the Shamima Begum case. Shamima Begum was 15 years old when she and her 2 friends left the UK without the consent of their parents and traveled onwards and ultimately ended up in Syria. And Shamima Begum had 2 children before the ages of 18. She was married off. This was one of the practices of the caliphate, to marry young girls to fighters, often as a reward system for those fighters. And just to be clear, under British common law and statutory law, the fact that she had 2 children under the age of 18 means she was statutorily raped twice, at least. She had a 3rd child who was born after her 18th birthday, and that all 3 of her children died due to conditions in the camps, pneumonia and other preventable diseases. In my view and the view of other special rapporteurs, we were concerned that Shamima Begum was groomed online. One of the practices of groups like ISIL and other terrorist groups of this kind is that they are very sophisticated about grooming young women and men online. And we've raised the view that Shamima Begum may have been under the definition of trafficking under international law, essentially trafficked to Syria. Now, it's important to know that Shamima Begum gave a number of interviews while she was in the camps to British journalists that were broadcast. And she said things that are clearly things that were not not helpful to her own case. But I think, as you'd know, Padraig, people often say things they shouldn't say, and particularly when they're not well advised. The UK citizenship stripped Shamima Begum and others, but she's the case that's been on the subject of significant litigation. So she was stripped of her citizenship on the basis that she continues to hold Bangladeshi citizenship. The government of Bangladesh has said she doesn't have Bangladeshi citizenship. They don't recognize that she's a citizen. So she has been rendered stateless by this process. And her team of lawyers and then a number of interveners, which included me on behalf of my mandate, intervened at both the Court of Appeal and the Supreme Court, arguing that her citizenship stripping was arbitrary. And as a result of that was both a breach of domestic law, but also of international law. And regretfully, profoundly regretfully, while the Court of Appeal was upheld that the citizenship stripping was inappropriate and inconsistent with the legal framework in the UK, the Supreme Court did not. So we are now considering, her legal team are considering their next move. I should say we have a number of cases of this kind heading to the European Court of Human Rights, as you can imagine, both on the obligation to repatriate and on issues related to citizenship stripping. And the mandate, I am also party to those legal proceedings. Maybe when we get away from all those legalities for the non-lawyers listening, it's just to say that I am struck by the extraordinary lack of humanity being extended to young people who made bad choices. There's no doubt. Traveling to Syria at 15 is not a good choice for any teenager to make. But the mark of a dignified and rights-bearing society is not how we treat those who behave well all the time, but how we treat those who transgress the law, and how we in particular treat our most vulnerable. And it seems to me very clearly that Shamima Begum was an extraordinary vulnerable young woman and remains an extraordinary vulnerable young woman, and is still in those camps without any obvious sight of her repatriation, and is now stateless under international law.
Okay, I'm almost finished. I'd be glad to know, but I have just a couple of final questions. One of them is on the COVID-19. Obviously, many states around the world have placed restrictions on human rights and freedom of movement and personal liberties in response to the pandemic in an effort to contain that, and many of those for health reasons. And are you concerned that some authoritarian states will use those restrictions and try to replace them on a permanent basis? Even some Western governments. Is that a concern for you? I'm not sure if it's within your jurisdiction at the UN, but I'm sure as an international human rights lawyer and observer, you'll be looking at this keenly. So you want to say about that?
Yeah, I mean, it's something that we've been really concerned about. So as in early March, when the pandemic was first starting to sort of shut down the world, my mandate issued a press statement following up from a report that I'd written in 2017 on the use of emergency powers, something that people in the north of Ireland are very, very familiar with, which is the problem of emergency powers, which is my profound concern that in the context of the COVID-19 pandemic, we would see a resort to emergency powers that were not proportionate, not necessary, and likely to be discriminatory. In the aftermath of that, with two NGOs, the ICNL and ECNL, these are two great civil society NGOs who work across the globe, we've set up a tracker together. The mandate I hold is set up what we call the Civic Freedom Tracker. And what it does is it's actually it's tracking the use of these exceptional powers across. And if listeners want to go in and see it, there's a map and you just drop into a country and you can see exactly what's happening in that country. So again, not to overuse the word epidemic, but we see an epidemic of exceptionality happening across the world. We also see a number of states using their counterterrorism and security powers to manage the pandemic. And I've been highly critical of that. The idea that you're using counterterrorism powers to fight a health emergency is absolutely inconsistent, particularly when we understand that the health effects of the pandemic are most often being felt by vulnerable communities who have historically poor relationships with the security sector. And the idea that you further empower the security sector to manage the health pandemic is really inconsistent. The big challenge I see now is reining in those powers. Governments, whether they're democratic or not, they seize on opportunities to enforce exceptions. And once we have exceptions, as we know in our own legal system, getting rid of them is extremely difficult. So our challenge right now at the national, the regional, and the global level is actually to be arguing for the ascendancy of regular legal norms, and in particular oversight of those legal norms by independent courts, and ensuring that we don't have overreach, because nothing, as we know, exceptions become permanent. And that's a really dangerous thing.
It reminds me of the Terrorism Act, which embedded permanently those emergency provisions which were subject to review.
Yes.
So it's a similar situation where you may find these laws become permanent. And if we're not vigilant, the human rights community aren't vigilant, or civil society, then we could have problems. And that's even in Western states, you know, we're talking about authoritarian states on the other side of the world. I couldn't finish this interview without asking you about the recent British government proposals on Legacy of the North. Obviously, you have a lot of experience in this area. Your book that I referred to earlier, The Politics of Force, dealt with state use of lethal force during the course of this conflict. And as I mentioned earlier, it was a very useful resource for me as a young student interested in that area, and has taken up a career dealing with legacy issues in the north of Ireland. The proposals, and I suppose most of the audience will know this, the proposals relate to a statute of limitations. But probably what people are talking about less is the proposal to end judicial activism with respect to civil actions and coronial processes, the inquest. And I don't think it's any surprise coming after the Ballymurphy inquest, which for me showed that these judicial processes can be an accountability mechanism and can be a truth recovery process. So many people and sort of my community aren't really surprised, you know, as soon as these processes become valuable to families, then they're taken away from them. And that's been their experience in the British justice system for decades. So maybe you want to comment on those proposals and how you see them, particularly the timing of them, and how extraordinary would this be for the British government to do this, and has it been done? I know there has been amnesties around the world. If you look at South Africa, that amnesty though was conditional on coming forward, admitting your role, that you're involved in a human rights abuse, and there's also a public element to it where that happened at a commission. So there's some level of accountability there, even though that I know the TRC was criticised. But how extraordinary is this in terms of international human rights law?
Yeah, there's a lot in there. I'm going to be careful and not comment too much on the pending legislation, because I may comment on it in my official capacity as Special Rapporteur. So I just want to leave myself the capacity to do that. As some in the audience may know, I am the Special Rapporteur on torture, communicated with the British government on the military overseas bill and on the provisions of that bill.
This would go much further than the overseas bill.
Absolutely. So I would say in the context of what we said there, I'm going to say what we said there, so I don't get myself into trouble about saying things before I've communicated them officially. We have to be careful that we can still say those things officially. But on that piece of legislation, my colleague Niels Melzer and I both underscored the impunity consequences, the breach of the international treaty obligations of the United Kingdom in regard to that piece of legislation, and the negative signals that it would send to other countries in terms of the permission to undercut existing robust engagement, rule of law capacity by the United Kingdom. So we've said that around the previous bill. So you could imagine that some of those things would also be relevant to this. What I have said, and I've said this to the UK government in many contexts, is, you know, so there are lots of ways. I work with countries who have zero functional rule of law systems, like literally the rule of law is ruled by law, not rule of law. And so there is an extraordinary importance to countries, first of all, in holding on to their independent judicial capacity, not undermining your judicial independence. That is the sort of signature strength of a democracy. And when you start to play with that, you actually start to kill your democracy by 1,000 cuts. And it's extraordinarily bad on its own merits to the legal system, but also again, the permissibility that it proclaims to other states to do so. I would also say, just look on amnesty. This is my colleague and friend, Louise Mallender at Queen's, is the world's expert, the leading expert. And I think she's been a guest at Féile before. So, you know, there's some good practice out there on amnesty. South Africa might be one, but there's also terrible practice on amnesty, of amnesties that have been given so the spectrum is wide. The UN Special Rapporteur on Transitional Justice has really advocated for, when amnesties are used, that they have to be done in a rule of law compliant way. They have to be done consistent with the rights to legal process, to reparations, and to upholding the rule of law. And I think that's the case. If there's discussions of amnesty, then they don't operate outside the law. But I think you're right. This is the place to start. We've seen families, and I have always, one of the things that has kept me, it's one of the things I bring with me when I go out to other places in the world from Belfast, is the strength of civil society in Northern Ireland, the way in which families and communities have held to the idea of justice for decades, and the lawyers like yourself who have committed their lives to representing those ideals, and is a testament to their commitment to the idea of law. And what are we without law? And when we see governments cutting down all the trees of law, like, to use that analogy from that wonderful play, we're left with nothing. And so I think it's extraordinarily regretful to see those moves. But I also would say that I think the spirit of and the kind of endurance we've seen from families, and the innovations that we've seen in Northern Ireland, the capacity to find ways to hold the state accountable, is actually unparalleled. And I say that because I travel a lot, see a lot. And I think we have to hold to that, and also support our families and support our lawyers for whom this life's work is often incredibly challenging and hard. It's hard. It's that big Sisyphean rock up the mountain and seeing nothing but the rock for decades. And I think that's really, really hard work, and supporting it.
Yeah, there are many objectionable aspects of the proposals in the document. I think it's 30 or so pages. But one paragraph caught my eye. I think it was paragraph 38, and I'm paraphrasing, but basically what it said was that the inquest and also the civil actions were impeding reconciliation. And in my opinion, that couldn't be further from the truth. In the last 50 years, the family's fight for those truth processes and the successful outcomes we've had in Ballymurphy was not the impediment to reconciliation. It was the blockage of that and the obstacles to that from the state. So that was objectionable, because reconciliation can be many things and many component parts. You'll know this from conflict zones throughout the world. Of course, it means it relates to inter-community relationships, but it also relates to the development of a human rights culture within that state, also accountability. And these proposals would certainly go against all that. In my opinion, this is not good for reconciliation, and it's a pretty dangerous time for our own peace process. And we call it a peace process because it is a process. We can't be complacent. We have to be vigilant. So, yeah, and I just wondered, my final question related to the same issue, whether if these proposals went through, and in my opinion, on the face of it, they're a breach of the European Convention on Human Rights. If these proposals went through, is there a role, and I'm asking you to gain it from your experience as an international human rights lawyer and your current role, is there any potential role for the Irish government, whether or not they go through with that? And is there anything in terms of what families can do or expect from the United Nations? Is there a role for the United Nations potentially if these drastic measures go through in the current form that we see within the proposals?
Yeah, I think it's a really good question, and I think it's a hard question. I would say two things. One is that the Irish government is in a unique role at this moment because it sits on the UN Security Council. And so one of the things that I think is Ireland has a much larger microphone on the global stage for the next 18 months than it has had since its last time on the Security Council, which was briefly in the 1960s, I believe. So I think that positioning, and if we look at what Ireland has been saying on the Security Council, and actually Ireland has been playing an enormously constructive and very powerful role. It was instrumental, for example, in enabling and ensuring the maintenance of the humanitarian access point into Syria in the very, very fraught negotiations we had a couple of weeks ago. It's made conflict and peace one of the central themes of its Security Council tenure. So I think for the families and for those of you thinking about this, really understanding and being aware of and being able to, not saying appeal to, but aware of that larger microphone that Ireland has on the global stage around conflict and peace is a very important entry point around the discussions related to impunity and the weakening of the rule of law in the post-conflict phase in Northern Ireland. And for the UN, it's challenging. I would say that countries who are highly sensitive to UN criticism are countries that you tend to get good results with. So in my own work, I've seen countries who are trying to augment their status on the global stage, countries who don't want to be seen as weak on human rights, countries for whom their status as a good complier is valuable to them, then often you can really have an impact. But it's difficult when a country appears impervious to international criticism. And so one of the challenges here is really whether or not this administration will have the kind of sensitivity to criticism and to understand, even as we criticize it from within in Northern Ireland, the Northern Ireland peace process, and you're right about the fact that the word process is often heralded as a massive success story for both governments. And I think they have an investment in the maintenance of that success story, not just as a kind of a tick box golden moment, but actually as a thing that is vibrant and real. And we've seen, of course, Brexit has revealed the shallowness of that, I think, in terms of the extent to which the British public as a whole has ownership of the virtue of the process with all its flaws. But finally, the other thing I would say is we have a new White House. And we have a new White House for whom democracy and human rights have become the center point of their kind of global engagement. And I think that's a really quite significant opportunity given the investment of this White House. And in particular, Joe Biden's long commitment to the peace process in Northern Ireland and his own sense of ownership of it. So it seems to me that's also a strategic opportunity.
Yeah, I think the soundings from the United States and Joe Biden's appointment, particularly listening to the Good Friday Agreement, and this obviously this aspect of it, but touching that, have been quite positive, constructive. I know the families are turning their attention to the United States, so that might be a helpful route. It's been a great time talking to you. It's been a pleasure, and you've been an inspiration to me as a human rights lawyer, and I know many others involved in this work. So I just hope that you keep up the good work, and you've still a long, long career. You've had an exceptional career thus far, but still a lot to do, too much to do. But I hope that you continue the good work, and maybe the next time we see you at FÉILE in person, you can update us on your great work around the world with the UN. So, go raibh míle maith agad, Fionnuala.
Gur míle maith agad bhfuilg, just anmhaoch a bheith anseo, agus buchas den tabar atá sé bhfuilg go déine, agus a táhacht amháin leis, agus go mé fuinneamh agus cócht agah lenne choinneála gimacht. Just my sincere thanks, and just to honor the work that you've done and the recognition of the battles that you yourself have fought, and really just that you pushed some big rocks up some very big mountains, and we're all grateful for that.